and yeah. So welcome. It's good to see you all. So September minutes, you have the minutes in your packet. And so we need to make a motion to approve the minutes if there's any changes that need to be made on the minutes. If people have had a chance to kind of go through them. And are there any changes to the minutes? No. Well, then can I have a motion to accept the minutes as written?
I move to accept the minutes as written.
Okay. And any objections? No? Okay. All in favor? Board members? All in favor? Let's see. What else do we have? Aye, Yvette. Okay. And Maya? I don't see a hand or Maya? Nick?
I was not at the last meeting, so I'll abstain.
Okay. Okay. Maya? I don't know if she.
I had to, someone came to my door.
Okay.
I approve.
Okay. Okay. Great. So the minutes are approved. Great. Thank you, everyone. So we have Tara Nevitt, who is the executive director of the Washington State Bar, who is going to give us an update on the WSBA's administration of Supreme Court boards, which is work that has been going on for a while. So Tara, you've got a little bit of time for us to cover this.
Well, thank you. Yes, this is a project that's been going on since I think 2020. And it's finally coming to fruition. And given that there's been a lot of change in the people, it seemed like it was a good time to update you all before we take this across the finish line. So I'm going to turn it over to the chair of the task force, Kyle Schicchetti. He'll do a little bit of sort of what were we doing, how did we get here, and then I'll do a little bit more detail.
Great, thank you. Kyle?
Thank you. And thank you, Tara, for that. I chatted with Tara a little bit earlier today, and we wanted to avoid as many acronyms as possible, and I'll try to kind of walk through. I chair the taxi cab task force, and that is an acronym. It stands for the Task Force Administering Xenial Involvement with Court-Appointed Boards. It's a mouthful. It was the result of a task force and then involving court-appointed boards, and that led into some kind of a taxi cab, and I had to struggle to figure out what those remaining letters were. But the basic understanding of this task force, which began several years ago, was the result of some tensions between the WSBA and court-appointed boards over the years. It's fine now. Thank you. It works now.
Oh,
okay. I had some issues with my video, and now I think it's working. And can you hear me okay too?
Yes. Yes.
Okay. Great. All right. We're good. Thanks, Nick. And so it was the result of these tensions over the years with court-appointed boards and the rule that requires the WSBA to administer court-appointed boards. And so that led to some a need for clarity in the roles and what administering means, how that works, and what kind of involvement and oversight there is for court-appointed boards. And there was nothing. So several years ago, we formed the task force. We invited 6 members of the Board of Governors and 6 members of the court-appointed boards to join in meetings to try to see what would be a good solution for clarifying roles, expectations, and how these the WSBA and court-appointed boards could better interact and have a dispute resolution process if there was ever a problem that couldn't be resolved between the parties. So we began with these meetings and initial discussions, and then over the course of a few years, we came to a policy, which you should have, and it was recently passed by the Board of Governors, to go to the Supreme Court. And then we wanted to make sure that all of the court-appointed boards were understanding the original intent of this policy, what it does, and how it was framed and how it was produced. Sal Mangia, former president of the WSBA, was the representative for a long time for access to justice for their board communications. And he was one of the more active participants. Also, former President Steve Crossland on behalf of the LLT board and former Governor Michael Cherry was also quite involved in these discussions. And we had the overall group, and then we would have these smaller work sessions with Sal and Steve and Tara and myself and Michael. And we focused on trying to get to the things that we could accomplish and identify what we couldn't accomplish. And so this doesn't go as far as some people would like. We do still struggle with the fact that court-appointed boards are independent, but the WSBA, as a mandatory bar association, has to be careful about certain things that we can be involved with. But up to a point, we did come to consensus on what things that we agree on. And we think we went a long ways toward figuring out how these relationships, the two bodies and multiple bodies with multiple boards could operate. And then eventually, if there was a dispute, which we haven't had in many years, but they have been in the past, what that looks like and how that gets resolved. And eventually, as Tara will go through with the particulars of the policy, it would eventually head to the Supreme Court for advice and counsel and a decision. And that makes sense to me and to the Board of Governors because, of course, the Supreme Court has plenary authority of both the WSBA and all of the court-appointed boards that it creates. And so then that would be the ultimate decision maker. Ideally, we would never get there. The purposes of the policy is to facilitate discussion, make sure that information is shared, that it is heads up are provided to the court-appointed boards and the WSBA when necessary. And I think all of those things that Tara will mention here in a minute would likely resolve any kind of differences, and the Supreme Court would never need to get involved. But if there was such a time that we need to we're at an impasse and we would need to have some decision maker in place, that would be the Supreme Court. We have not presented this to the Supreme Court. We've had conversations with them over the years. The Supreme Court could say, no, we want to do something different, or it should be approached differently. But we haven't gotten there yet. So you are the final stage before we present it to the Supreme Court, and then we'll go from there on what it looks like, either be a court order or a rule or what the court thinks is necessary in this instance. I'm sure we'll follow their guidance. So with that, I'll turn it back over to Tara for anything that I've forgotten and a discussion about the specific policies and processes that are outlined in this policy.
All right, thank you so much. I was noticing in your materials that you don't actually have a copy of the policy, which I apologize. I'm sure that's an error on my part. I sent it to Bonnie and she's going to send it out to you now. So I'm sorry that you didn't have that already. Although the good news is the memo that's in your materials does walk through in pretty excruciating detail what's going on in the policy. And I think, I'm no doubt you've noted this has taken 5 years. And I think that's I think there's a lot of reasons for that. One, I think that we're trying to address conflict. Some of that conflict is probably necessary and appropriate. And yet also we want to figure out where we can eliminate unnecessary conflict and unnecessary tension. That's not so fun to talk about. Also, there were a lot of interests here, and there are some conflicts that we just couldn't really resolve. And so it took a really long time. And then, of course, we had to keep updating the Board of Governors and the Supreme Court boards and bringing people along with us. So I think I would like to, I want to start a little bit by just talking a little bit about the nature of the conflicts that we're trying to address. And some of you might know that when I started at the bar 11 years ago, my first job was to work with the Access to Justice Board. And at that time, there was a lot of tension between the board and the Bar Association. And I learned that that was not unique to the Access to Justice Board. I think almost every single Supreme Court board has had a period of significant conflict with the organization, or vice versa. It goes both ways. And again, I think that's because it's set up in a unique way. Sorry, I'm just gonna look at my notes here for a minute. So the conflicts almost always relate to resources or decision-making authority, as you can imagine. And ultimately, there's sort of one central question that drives all the conflict, which is, to what extent are these entities, the court-appointed boards, independent from WSBA? And as Kyle said, we determined that, of course, they are independent in some way. The bar is charged with administering these boards under a court rule. It's called General Rule 12.3. It's like one really long run-on sentence, which doesn't provide a lot of detail, or it doesn't answer a lot of questions. So the court set that up for a reason. They are the ones who appoint the members for a reason. They call them Supreme Court boards for a reason. So they're clearly of a different character than the other entities that the Bar Association administers. But at the same time, many of them are funded by WSBA license fees, and there are certain restrictions around the use of those fees. And a lot of the work is carried out by Bar Association employees who are also subject to whatever the bar is subject to. And they also lack a separate legal identity that would allow an entity to go open their own bank account or enter into their own contract. So these are all the areas where sort of the conflict has arisen. I think what I would like to focus on, because the policy tries to do a few things. The first thing is it tries to just capture our current practice, because there's a lot of things that we do in practice that work just fine, but it all just sort of lives in our hearts and minds, and it wasn't really written down anywhere. So we wanted to write that down so we could hold ourselves accountable to the way that we do things. But I want to focus on the second thing that it tried to do, though, was actually answer some questions and bring some clarity to things that we didn't already have clarity on. So I'm just going to run through a few of those briefly. The first one is we really tried to identify the nature of the relationship, and specifically we stated, which really wasn't stated anywhere, that the boards are independent from WSBA. And then we defined what that means. And so when we talk about independence, what we are referring to is that the boards set their own priorities and their own goals, and that they determine how to carry out their duties and functions that have been authorized by the Supreme Court boards. So that was kind of a big deal to just state that. The other thing that we did was, and in that same sentence, we talk about, so even though they're independent, that doesn't limit the Bar Association's authority or responsibilities to direct our own activities and to take action to protect the organization from liability and make sure that we're following all the rules and case law that govern us. So along those lines, a few other things that the policy says. It says that Supreme Court boards who operate with license fees are subject to First Amendment limitations on the use of license fees, and that's something that wasn't clear. It also puts a duty on the executive director to notify boards when there's a proposed rule or policy change pending that might have an effect on your activities. It also puts a duty on the boards to notify me if you are doing anything that potentially could expose the organization to liability, so that we can have a conversation about it before that happens. It encourages the bar to get feedback from you about your staff liaison's performance, and to get feedback from you about what kind of skills and experiences you're looking for in your staff support. And I think, I guess two more I'll touch on. Budget was an area where we really tried to provide some clarity, because I think different boards had different experiences depending on the way that their staff liaison managed it, and also just the history of their group. So specifically, the policy states that boards should be funded at a level that ensures they can meet their functions and duties. Under the court rule, the Board of Governors has the authority to establish that budget. But we said in the policy that that budgetary discretion cannot be used to interfere with a board's independence. And that was something that, again, wasn't written down anywhere and was really important to the Supreme Court boards participating. And the last thing I'll add is that we provided a conflict resolution process that calls upon the Supreme Court to be the final decision maker if we get there. And I think that was also important because as we were going through this, we acknowledged we can't answer all the questions. We can't anticipate every area of conflict, but we would at least like to have some agreement about how we will resolve conflict. So I think I will stop there. And again, I apologize that you didn't have the policy itself. So if after you have a chance to look at it on your own, please feel free to reach out to myself or Kyle if you have questions about it. But if anybody has questions now for us, happy to take them.
I have a question, Tara. So thank you, first of all, both you and Kyle for sharing all that information. And we know that it's been a very long process and that Sal has been in there and really doing an amazing job of helping to kind of clarify all that and well, the work, right? And so, but my question, I might have more once I look at the whole policy, but one of the questions I had was related to boards notifying WSBA if they're doing anything that could jeopardize, compromise the organization, right? And so, you know, I'm thinking as the board chair, I'm thinking, okay, so what are those kinds of things? What if we do something that, oh shoot, that compromise? So are you going to have any kind of examples in that policy? Are there, or we just kind of are supposed to know?
Good question. There are not examples in the policy, although that does make me think that if the court approves it, because I think also we forgot to say that the next step, or maybe Kyle said this, the next step is to send it to the court. And who knows if they'll approve it or not. But let's say they do. We probably might want to do some training or orientation around the policy. So I think there we can provide some examples, and I can certainly provide one now. But I also want to point out that your staff liaisons are usually going to be well trained in the legal issues. So, you know, and one thing we didn't address is, let's say there is a legal risk and, you know, and we talk about it and you still want to do it and WSBA still has concerns. You know, the policy doesn't say who gets to decide. What the policy contemplates is that we at least have a conversation and maybe we can come to a meeting of the minds about how to proceed. Maybe if one of the parties feels strong enough, then we engage the conflict resolution policy, but it doesn't sort of say out front, this is who gets to decide. Basically, we both get to act in our own interests and do the best that we can. I'll give you just one brief example, which was another one I touched upon, which is that as some of you have been following, there's been a lot of litigation over the last couple decades and really throughout the history about the Bar Association itself and the fact that it's mandatory, but it also engages in speech, which is protected by the First Amendment. And so that all those restrictions, they tie to license fees. And so and that means that that license fee money can only be used for activities that relate to regulation of the practice of law or the quality of legal services delivered to the public. Now, the good news is the vast majority of what the ATJ board does is squarely within that. So it shouldn't be a big area of concern. But let's say that you wanted to take a position publicly on something that arguably did not fit within those limitations and was purely a political issue that did not relate to regulating the practice of law or improving the quality of legal services. That would be an area of legal risk, and that would be one where I would say, let's please talk about it before we do that.
Okay.
And I might add on to that a little bit. There's been some more recent decisions out of the Ninth Circuit that also bring not only freedom of speech, but also freedom of association into this. And the most recent one from the Ninth Circuit involving an Oregon case, did find that there were violations of freedom of association with political speech. However, there are some easy, or at least the court believes there's some easy solutions to that, and they outline those. Now, it's likely this is going to go to the Supreme Court, the U.S. Supreme Court, and who knows whether they'll take it or not. But the Bar Association itself is very cognizant of these decisions around the country, some of which are conflicting, that make it more difficult for Tara and WSBA to make sure that they're doing things that are not going to subject the WSBA to lawsuits. Also, one other thing that I might add is there were things that we didn't try to accomplish in this document. And so we envision this as something that's going to be, used, developed, improved upon over the years, and with updates as we come into, if there's conflicts or if there's things that we can improve upon, we may want to revise it at some point, which makes me think that either a court order or a policy of some kind would probably be the better animal for that, because then we can more easily change it rather than a court rule. But that will be discussed with the court.
Okay, great. Thank you. Anybody else have any questions? Well, thank you so much, Tara and Kyle, for this presentation, for all the work. And we'll definitely look at the policy, and there might be some other questions from the board or from others that are here on this call. So thank you, really appreciate it. And Tara, I think we're getting you out of here in time so you can get.
Yay! Thank you so much. I appreciate the opportunity.
You're welcome.
Thank you.
You're very welcome. Thank you, Kyle.
Bye.
Bye-bye. So the next thing we have is, let's see, I put this on the agenda because we just want to see what we have is planning for potential impacts to client communities. I think it's something that we're all thinking about. What kind of changes we're already seeing some, some changes that are taking place, or potential changes that'll take place that could have adverse impacts to the communities we all serve. And so wanted to just have a conversation with this group. What should we be thinking of? What do you know that's going on already? What should we be aware of? How do we start having this conversation? And this is the beginning of a conversation I think we're going to be having for a while. And so if anybody's got anything they would like to share of things that are happening that we might not all be aware of also things that are happening adversely to communities, but also work that's taking place by organizations and individuals, institutions that are addressing or beginning to plan for how to address some of the issues that we are thinking are gonna take place. So anybody want to chime in? This is an open discussion. Just want to take a few minutes.
In the immigration legal community, there's already been discussions and like lots of talk about what's gonna happen in the next with the next presidential administration. So there's already some work being done with different groups being prepared, or in different people willing to step up on like late breaking stuff and in emergency stuff. Yeah, there's foreseeable changes in ICE enforcement and CBP down the line, and also talks about change in ICE's sanctuary policy regarding schools and in churches and stuff like that. But again, that's not that's a possible change. That's not something that we know about yet, but it's rumors about potential changes. So yeah, at least in the immigration practitioners, yeah, I think there's already been a lot of efforts to be prepared in terms of people doing work with detained people, stepping up, you know, in people's like myself scrambling right now to file all the stuff I can file now, while I know what's going on right now. So yeah, I'm tired. I'm tired. I'm trying to get a lot done. And I have like a month like 5 weeks. 5 weeks to get all I need to get done. So and I know in refugee resettlement, they are really scrambling to do what they can. And they're going to be working through the holidays. Like our refugee resettlement agency that we're affiliated is going to be working through the holidays to do what they can now, while they still have the power to, well, that they know of, before any potential changes come down the line, in 5 weeks, because we don't know what's going to happen after January 20th. So we're doing what we can now. But yeah.
Thank you, Mercedes. Anybody else?
Do you see Vanna and Murph's hands up, SB?
No, I don't. Let's see, I don't know who had it up first. I don't know why I can't see it.
Murph can go first.
Yeah, go ahead, Murph. Sorry.
Oh, I was after Vanna, so I'm happy to wait Vanna unless you want me to go.
Go ahead.
Okay, go ahead, Murph.
Yeah, can you hear me?
Yes.
Okay, sorry, for some reason my camera isn't working. It doesn't detect the camera. Yeah, so we're working a lot around the Keep Washington Working, and doing that. I think what I'm curious about is what the ATJ board sees their role in this going forward. So that would be helpful to know. We think it's really important. I think it's really important that the court, particularly the Supreme Court and other levels of the court and the ATJ board, stress the rule of law in Washington, and that it will be upheld and followed. There's already been some issues around that, but I think a strong statement around those structures would be hugely important, and also that the communities that will be most impacted going forward, services to them will be upheld by the courts and by the ATJ board. So that's where we're at. The other thing that I think is really important and also could be included is the internal safety of our communities doing this work. So we have put together some safety protocols for folks who are going out into the communities, who are going to the police stations and giving trainings on Keep Washington Working to travel in twos, what to do if there's an issue or a confrontation with the police, what to do if there's a confrontation for others. During the last administration, one of our offices was vandalized with racial slurs. So making sure that all the folks doing the work are supported, who may be even more impacted now, if that makes sense.
Thank you. And Murph, before you speak, let me just say that we will do, I mean, you mentioned what role the ATJ board will have. We're, besides what, the advocacy, the work that we do, we definitely will push for the recognition of the rule of law. And I'm glad that you brought up the issue about safety, because it's a concern that I've been thinking of for individuals and organizations. And we're going to see an uptick in some incidences, unfortunately. And so we need to be aware and figure out how to make sure and push for the protection of the people doing this work, and the organizations. So I think those are conversations we need to have to figure out, well, then what do you do? And what role do we play as a board? How can we be supportive of the that area of work? How do we make sure that the rule of law is followed, and that the services that are needed I mean, it's the Access to Justice Board for the state and around civil legal aid, but that's, you know, there's a lot of other institutions that intersect with that civil legal aid. So I think that's something that we're having those conversations now because we're in the process of a strategic plan. So your questions come at a very good time because we're aware of what it is that we're going to be facing. And so how are we going to address that? How are we going to make sure that we're an entity that is useful and supportive of organizations that are doing this work around the state, including people that are on the board, right? People that are on the board that are working in some of these organizations, and attorneys that are doing the work, like Mercedes, who is very tired. So thank you, Murph. Let's see, Vanna?
Thank you. Thanks, Murph. I know that our board is currently doing a lot of changes, and part of what we are doing is making sure that we practice our self-care and to create a strong foundation so we can do this work, you know, with the conscious mindset to where we can support other people. Because if the foundation isn't strong, you know, everything's going to crumble all around us. I just did want to ask if there's any organizations that's implementing any surveys or something to where like the clients can give feedback on the way they are getting treated from the organizations that are serving them. Because I'm reflecting back when I received services from the public defender's office, and I know that there's other people in the community who have been complaining about the services they have been receiving, but they're afraid to, you know, give that feedback or voice their concerns. I mean, we are accountable for how we are treating the clients. So is there a way where the clients can give the feedback without being retaliated against? And I just wanted to remind everyone, like right now, the clients need us more than ever. And we need to make sure that we are giving the best, highest quality service. And in order to do that, we have to take care of ourselves. And that's all. Thank you.
Anybody else?
I just want to add that I really appreciated what Murph had to say. I think on the Access to Justice Board, I think we could really ensure accountability and so a sort of space where everyone has access, like if there was a time to make sure everybody had access to civil legal aid, it is now. And so I really appreciate and I really hope that we continue the conversation of maybe sending a letter to the Supreme Court or to civil legal aid providers or something to make sure that now more than ever there is this support and being able to see civil legal aid as like something that is as a most important, because I think it's going to be one of the ways in which we can really fight back or have some sort of resistance to next year. So I just want to appreciate those words and really hope that I see something like that within the Access to Justice Board.
Thank you, Maya. Anybody else? I don't want to cut off anyone. And I'm learning how to be comfortable with silence. not want to rush in. So I think that one of the things that's going to be extremely important is communication. Because we need to try to be as informed as possible as to what's going on out there. How people are being impacted, how organizations are being impacted, and in which way. You know, I mean, we don't have a 911 that we can call and say, hey, you know, this, and get somebody that goes out and deals with it. And, you know, I don't know, is that even something that's possible? How do we, I think communication is going to be key over the next few years in a way that we probably haven't maybe done in the past, but then figure out with, you know, things that come up, how do we address them? How do we, can some of those things be done collectively? Are they going to have to be done by individual organizations? I mean, I don't think anybody needs to be left out there on their own, shouldn't be left out there on their own, but we don't have the answers yet. And I think that these conversations and holding each other accountable as well, you know, for whatever it is that the ATJ board can do, we will do. And if we're not doing it, tell us, you know, and if you have a sense of, why don't you guys do this? Why don't you guys do that? So, and we've been exploring our role in this process, really discerning what the role of the ATJ board is on a statewide level and within the legal community, and how we can be more effective and more impactful and more supportive. In the most practical ways that we can, but practicality might be tossed out the window at some point. I don't know, but so these conversations, I think, will be something that we'll continue having to we need that communication, is what I'm saying. And Murph, I appreciate your comments, and Maya and Vanna, and other people have comments. We'll have time to do that in these meetings. And there's other places where some of those conversations happen with Disco. Michael, I see you're here. So if there's not any other, anybody else has anything to say, we're going to move on. I'll just make sure there isn't another comment or question. Okay. All right, great. Thank you, everybody. The next item is the suggested amendments to these RPCs that Nick is going to present for us. Nick?
Yeah. Hi, everybody. Can you hear me okay?
Oh, yeah.
Great. So going to go over a couple of the proposed amendments to the RPCs that are in the board's packets, page 10 to 18 in there. And this came about because the Supreme Court Rules Committee asked the ATJ board for its thoughts on these proposed court rules. Generally speaking, the proposals would amend 3 different RPCs to provide that lawyers can share a portion or percentage of a fee they receive for their work with nonprofit lawyer referral services. And the proposal originally was published for comment in January 2024, which, given everything that's happened and apropos of the discussion we just had, seems a long time ago. But it also is for rule purposes. And the comment deadline was in April, and they received no comments. And so they were kind of wondering why that was the case, or if the rules were just perfect, which of course is never true. And so then they asked the ATJ board to follow up and see if we had any comments on this. And the idea behind it is a good one, in the sense of, the idea is that sharing the fee with a lawyer referral service that qualifies under 501c3 or is registered under the Washington State Nonprofit Corporation Act would help those services continue to provide, the services they provide, for lack of a better way to say it. And so the interesting thing about Washington State is that Washington State is one of the kind of exceptions to the rule in terms of across the United States with regards to allowing the sharing to happen. We have kind of more restrictions than other states. There are other states like us, but opening that avenue up and providing a path with less restrictions should, in theory, provide more access to justice. And that's part of what the Supreme Court Rules Committee and the Supreme Court was interested in, our view of that. And so the Rules Committee met on November 15th. We had Chris Durbin is still co-chairing that. Dave Keenan appeared there. It was great to see him. He has not left for the Bahamas, as was rumored. He's still around and he's still participating, so we appreciated that as well. And we had a good discussion about this, and everyone is generally in favor of it, but they asked us a tough question, which was, you know, can you essentially give us evidence that this change in the rule will provide more access to justice? And I think you can look at other states and see examples of how it might work or how that would help, but we don't have that rule in place here, and it's hard to gather that information. We could survey folks, but that would take a long time. And so, you know, there is no opposition to this. The court is open to doing it. So it seems as though it would be a good change and a good change for us to support. And the Rules Committee was generally of that view, but the Rules Committee was also not interested in having more work put on our plate or the board's plate in terms of trying to gather that extrinsic evidence when it would be very difficult to find. So I think generally the idea of allowing the fee sharing should provide more money that would come in normally just to the attorney, but also that money could go to the lawyer referral service as well. So let me pause there for a second and see if there's any questions. And there's one other point that was made that I wanted to bring up.
Are there any questions for Nick?
Okay, so generally, I think
Nick, before,
Oh, yeah, go ahead.
I just want to make sure I got clarity. So
Yeah.
you're saying that there's no opposition for this, for if we were to push forward for this rule?
Yep.
Right? That's what you said?
Correct. Yes.
Okay. So the need to do this research or survey or study to get data, which we couldn't get because we're not there, we're not doing it, so we don't have that data. We don't have to worry about that, right? That's what you're saying?
Yeah, I mean, I think there's really the long and short approach to this in terms of two options. And the short approach is to say, yes, this is a good idea in theory. We agree with it. We've seen other states that are trying to do it. Let's move forward. Or it's, well, actually, let us pause and study this and see what the effects might be and look across the country and ask people in our own state. And then you're looking at another year of time. So it doesn't seem like that would make a lot of sense. And the Rules Committee was of that mind, which is the ATJ Board should just say that this is something that we support and don't see any downside to. And I think that's generally the idea.
Okay.
The only question that came up, which was brought up in the Rules Committee that was kind of interesting, is what exactly is the definition of a lawyer referral service? And who qualifies for that? Because if it's fee sharing that's allowed, does that mean, for example, what we typically think of, the folks that are across the state specifically handling, pro bono cases? Or, for example, is it something like more or larger, like maybe CLS or NERP or something like that? Do they qualify as well? And it's not perfectly defined, and it would be interesting to see how that would play out. But at the same time, that wiggle room allows for an opportunity for future rule improvements, but also potentially avenues for other services to benefit. So anyway, I just wanted to bring that up. There was a discussion about that. There was a discussion about changing the language. Be happy to hear anyone's thoughts here. But after a long discussion in the Rules Committee, I think the idea was more, again, let's try to make progress because Washington State is behind in this, and let's get these rules in place because no one's opposing them. And then if they don't work out, in the sense of there's some confusion there, then maybe that's a future rule amendment. But I think most folks thought that we would probably be able to work that out even with the new rules in place. But I see Karen has her hand up.
Yeah,
Yes.
Karen?
Thank you so much, Karen Pillar. I work at Teen Child, and that was one of my questions as I was listening to you, as I wasn't exactly sure. I was looking back at the RPC, like what is a lawyer referral service? And I was assuming the bar, like but it sounds like that's not necessarily what's being contemplated. But my question is actually bigger than that, which is if we did this in like thinking about humanity as being like the worst group of people on the planet, would that create a financial incentive where some group, like a Ladies for Liberty type group, could call themselves a lawyer referral service, talk to a lot of people who have complaints, funnel them to a private firm who would move those complaints forward, and there'd be like a quid pro quo, right? Like you're going to get a big cut of whatever we get. It's sort of self-generating. I don't know. I mean, is it? It sounds like it's possible. It could be used in that spirit, maybe. And maybe we're willing to take that risk. I'm just curious because it doesn't sound like a bad idea generally, but I just am learning. I'm learning this through this other RPC discussion we've been having on 1.8, that like some of the hesitation around that was that not everyone who calls themselves a nonprofit is moving in a direction that feels like it's oriented to justice the way many of us think of it.
Yeah, it's a great point. I think, like I said, there are other states that have restrictions like Washington State, and historically it's possible that piece of this could be part of the reason there is a restriction in place. But I think ultimately the Rules Committee looked at this, and again, back in this very early of 2024, the rules went out and there were no comments from anyone. So like I said, there's really no opposition to this. But I think the bottom line view from the Rules Committee was, don't have perfect be the enemy of good. And whether that's what you agree with or not, I think generally speaking, seeing what's happened, there are some studies, or there is some evidence from other states that they're seeing that these fee sharing arrangements help the nonprofit lawyer referral services, generally speaking, in the access to justice area. And in theory, it should be straightforward. But of course, if other people qualify, it's vague enough, they can use it how they want. But again, that's where, there's two options. You implement the rule and you test it out and then you revise it, or you theorize about how it would be implemented and what the pros and cons would be, and then you decide later whether to implement it. And I think that, again, not letting perfect be the enemy of good and no one else opposing it, the idea was to try to move forward and see if the benefits outweigh the costs, because the theory is working in other places. But, we could talk about it all day. And I know there's other agenda items, but Vanna has a comment.
Yeah, Vanna.
Thank you. I just wanted to share that if that was possible, definitely help out an organization, especially a grassroots. And we don't often see that too much, just from my experience trying to get support. And our organization started from 2015, and that was the kind of services we wanted to do. We wanted to provide referrals to civil legal aid. And then again, it's like there's something missing, like that lack of trust. If the organization has mistreated the community leader, what makes you think that the community leader is going to refer you to that organization? And so there's a lot of bridges that need to be built before we could get to that point. But that'll definitely help fund positions and the costs it takes for organizations to sustain. I always hear a lot like, oh, we don't have the kind of money to support you or to sponsor your event, but we'll give you a couple hundred, like 200, to support. And of course, we're hungry, we're thirsty, we're going to take it. Every little bit counts. But that will definitely help out, smaller organizations that are grassroots. Thank you.
Thank you, Vanna. Any other questions for Nick?
So SB, then just next steps, I'll go back to the Rules Committee. We're meeting in January. I'll tell them the board agrees that we can kind of just go forward, and then the Rules Committee is going to draft a response letter to the Supreme Court, and I'll run that by everyone at our, I guess, February board meeting, and then we can send it out.
So what we would need to do, Nick, is this board would need to vote to move it forward. We need to actually have an action here at this meeting. So if there are no other questions, is there a motion to move forward to accept the suggested amendments to these RPCs?
I'll set that motion.
Is there a second? Okay, thanks, Nick. All those in favor?
Aye.
Okay, the motion passes. Thank you, Nick. Thank you for that work. And then we're gonna have to be paying attention, right? So, okay, strategic planning updates. So the strategic plan of, we're still continuing with that work and we should be done soon. Maybe in the next couple of months we'll be done. And where we're at right now is we've gone through, we've created our values or updated the values. We've updated our vision, that we're working on our mission right now. And there's, as I mentioned earlier, there's a lot of detailed work going into this and looking at the history of what we've done, where we're at right now, and then what the future looks like. And that our strategic plan has to be in the context of those three eras, if you will. And so we have our meeting with, we'll be meeting with the consultant a few times before February, and in February have a retreat with the board to go over the mission and the other pieces. And we're looking at being done by March with our strategic plan. It was very helpful getting the feedback from Alliance members and others in the community through that survey has really kind of helped us go forward with this and really look at it's. We refer to that survey and the feedback that we've gotten a lot during our conversation. So thank you very much for everybody that gave their feedback and their input. But you'll hear more about that in February. We'll be meeting again and for a chunk of time to be able to kind of finalize our strategic plan. So I don't know if there's any questions. If not, okay, great. Thank you. So let's see, I don't think we have, Nadia's not here for the Equal Justice Coalition update. Bonnie, was she gonna be here?
Yeah, I'm not sure. I don't see any of the folks who are going to be doing funding updates.
Yeah, I don't see any of the folks. They're usually here, or some of them are, not all of them, but some of them are here. So we don't have those updates for today. So what we'd like to do is if there's any other updates that somebody here has that you'd like to share. Michael, I need to talk to you after this, so I'm going to give you a call or I'll email you. I don't know if you can hear me, but I'm going to be calling you. Okay. Okay, great. I don't think there's anything else. Unless there's anything else, just make sure and continue to help us with the conference. But I also have an announcement really quick. And some of the board members are going to hear this for the first time because we haven't been able to announce it publicly yet. And I just got an okay for doing that. One of our board members, Bryn Felix, who is out in the peninsula, is having to step down from the board. So we're going to be looking for another board member. She was promoted and has a lot more responsibility and doesn't think that she could cover those responsibilities and the responsibilities of a board. She has been an incredible board member, very active, and we're going to miss her. And so, so what that means is that we're going to be looking for another board member, and I keep kind of pushing for finding somebody from Eastern Washington, so that we have, we're trying to kind of round out the representation geographically. I think we've done a good job in rounding out representation in terms of the different racial groups and different communities around our state. There's still a lot of work to do. It's never done, but if you can please help us get the word out, and we'll be sending out that information soon with the application, and we'll make sure that all of you get it. So if you know of anybody in Eastern Washington that should be on this board, please, please, please help us out and send us their name, talk to them, have them contact us, and we'll get that information out soon. I think that's it. Okay, any other announcements? Okay, wonderful. Thank you, everybody. Have a great weekend. Have a great holiday, and we will see you in January. Thank you so much.
Thanks, SB. Nice to see
Thank you.
everybody.
Bye-bye, Murph. Thanks.